every year is going to go through a JP court or a municipal court. Okay? I believe that the JP judges and the municipal judges may be the most important judges on our system. Why? Why? Because that's crazy, right? Why do you say that? Because a third of the state's population is going to come in contact with the judicial system every year. And they better have a good experience in that system so that they have faith and confidence in our judicial system and the rule of law and that things are being done fairly. Because if people lose confidence in the judicial system, all heck breaks loose. Right? And we might be starting to see some of that. So district and statutory county courts dispose of hundreds of thousands of cases a year. We're going to talk a little bit about what they do and how they do it here in a second. The 14 courts of appeals dispose of greater than 10,000 cases a year. In the 6 years that I was on the court, I was credited with offering over 600 substantive opinions. Going back and looking at it, I think the ones that were really, really substantive were probably in the 420, 450 range. So typically we try to balance the level caseload among the appellate judges around the state so that everybody has a similar type workload. Each justice in a normal year, not a COVID type year, is going to be responsible for 60 to 70 substantive opinions a year. So we're cranking out an opinion at least once a week. We're working really, really hard, we're working really fast, and you need to make sure that you have people that can do that. I think there are two characteristics that you need to have to be successful at any job, but particularly on the Court of Appeals. You need to have people who have the willpower to do the job well, according to the rules, and the horsepower to do it. Willpower and horsepower, very important. The highest courts each decide roughly 90 to 100 cases or more a year. That's not very many. So you need the people on the intermediate appellate courts doing a really, really good job because, as Justin said, the Supreme Court is sort of a backstop. Well, they can only take so many cases a year, so we need them right at the intermediate level. What do trial courts do? I love trial courts. They're extremely important. I don't in any possible way want to denigrate our trial courts. But their primary function in the system is the process managers. We talked a little bit about the volume of cases that they process. Their job is to make sure that things get done, that people file their petitions, answers get filed, the cases move to trial, they get tried, a result happens, and then it moves on. And if somebody doesn't like the result, then we can go up to the courts of appeals. Very, very, very important, but a decision in a trial court affects the rights of those parties. And that's it. Right? Or their kids. So, what do the courts of appeals do? We are the dark matter of the legal universe. Right? We hold everything together, but nobody knows we're there. Our function fundamentally is to preserve the rule of law. Like I said, we write these opinions that interpret the statutes and tell everybody what the legislature meant. Okay? And in a stare decisis system, it's what we say the legislature meant that counts. Okay? We're the final word in a case 99+% of the time. If somebody doesn't like what we did, and half the time, or half the people don't like what we did, they have a right to ask one of the higher courts to take a look at the case and review it and decide if there was a mess up. The intermediate appellate courts, particularly the Dallas court, because the Dallas court is the largest, busiest intermediate appellate court in the state of Texas. People pay attention to what we do on that court. We write a lot of opinions. We do that. So we have an impact statewide. How do we do it? It's a record review. What is that? There are two parts to a record. There's the stuff that gets filed at the courthouse. That's called the clerk's record. And then if there's a trial, there's a court reporter there. We've all seen it on TV. The court reporter's taking everything down. That's the reporter's record. And when we decide a case, we look at the briefs, the appellants, the people who lost, get to file a document with us called a brief that says, here's what we think happened in the case, and here's where we think the trial court got it wrong. And so you read these briefs, and most of the time you go, oh my gosh, that's awful. How could the trial judge have possibly have done that? And then you get the Appellee's brief, the other side's brief. And you go, oh my gosh, where did the appellate come from? You know, you get the Paul Harvey moments. And I know virtually everybody here remembers Paul Harvey. Okay? Here's the rest of the story. So that's what happens with the Appellee's brief. But then we have to write that opinion that says, okay, here's the issues, the concrete issues that people presented to us. Here's the facts that is in the record. We don't get to come up with new facts. We can only deal with what's in the record. And here's the law, and here's how we apply the law to the facts, and here's the result. And we have to publish that. We have to make it available to every citizen. And there are nerds out there, kind of like me, that just read this stuff for fun. Believe it or not, they're very interested in it. But when we, on the Court of Appeals, write an opinion, we have a variety of different audiences that we have to write for. And I think it's important for the justices to understand that. Of course, your first audience is the parties to the case. And I think it's really important that they be able to understand your opinion, our opinions, so that they may disagree with the result, but they go, well, I understand how they got there, and it makes sense. I can have confidence that they're doing their job. I have a good friend, Rob Gilruth, who lost on an appeal, an opinion I wrote. Incredibly complex case, 45-page opinion. And when he got it back, he sent me an email and he says, well, Bill, you know, I disagree with the result, but you wrote a really nice opinion. And that's what you want, right? You want the people to say, everybody in this room ought to be able to pick up one of our opinions and say, okay, I get it. I understand what the issues are. I understand what the law is. And I may agree or disagree, but I get it, how they get there. Okay. We decide cases in panels of 3, for the most part, on an intermediate appellate court. And in the Dallas court, we do a better job than any other court in the state of having oral arguments, where the lawyers get to come in and argue their case with us, and we get to have interaction with them and do that. I think that's a very important part of what the appellate courts do, because it gives the parties, particularly, a sense of their day in court. Right? Who wants to send off an appeal and have a computer spit out an opinion 6 months down the road, 9 months down the road? Everybody has their chance to argue their case and do that. That's really important. Okay, why do we care about the courts generally and the appellate courts? The legislature has written a statute that governs every aspect of your life, virtually. From business transactions, to families, to estates, to criminal law, to you name it. There's hardly anything that you can do today that the legislature or Congress hasn't written a statute on. Let's talk about Texas. There are 181 elected members of the legislature. Every case that we decide, like I said, has at least one statute in it that we have to interpret and apply. When that statute was created, there were 181 elected representatives that were involved or had the opportunity to be involved in creating that public policy. The governor has his or her signature on it. That's 182 elected representatives. It's what we decide those 182 meant that counts. Right? So in my very first campaign, I was visiting with a former state representative, and I said, John, you know, really, I don't want to be offensive, but I think the appellate court judge's job is at least as important as the state rep's job. And he goes, no, Bill, you're wrong. And I went, oh, crap, I just offended this guy. And I want his money. It's more important. When you think about the impact that an appellate judge can have on the law versus one state representative, I think he's right. Our job, and I wrote about this in several opinions, part of our job is legislator accountability. It's very, very, very important that we apply statutes the way they're written so that the people can hold the legislators accountable to the words they use. Right? And vote them out of office if they don't like that, or put them back in office if they do like it. But if we start applying what we think the law ought to be, as opposed to what the legislators came up with, we're messing with the system. We're taking away your rights to hold your legislators accountable for the words they use. What do the Supreme Court and Court of Criminal Appeals do? They're discretionary review courts. We have to take, in the Court of Appeals, they have to take every case that comes their way. That's why we end up writing 70 opinions per justice per year. The Supreme Court and Court of Criminal Appeals get to pick and choose what they want and decide what they think are the important issues. Each judge, so the story on the Court of Criminal Appeals and Supreme Court is the titles on the Supreme Court is justice. The title of the Court of Criminal Appeals judge is judge, right? So the joke is there are no judges on the Supreme Court and there's no justice in the Court of Criminal Appeals. But each judge or justice is going to write roughly 7 substantive opinions a year versus the 60 or 70 that your immediate appellate court judges are going to do. How do our intermediate courts compare to other states? Population numbers are a little bit off because I haven't changed it for the last census. We have 14 courts and 80 judges for a population now roughly a little over 30 million. 8 more appellate courts than California with 10 million more people. Although they're getting fewer and fewer people all the time. And we're going to talk about how that is, and problems that 14 number creates, and possible solutions to solve those problems. So how did we get here to 14 intermediate appellate courts? From 1836 until 1876, we had trial courts and we had the Texas Supreme Court. And that was it. It worked just fine. Wasn't a very big state population-wise, and so the caseloads weren't all that heavy. But as the state grew in population, there was too many cases for the Supreme Court to handle. It's easy to create new district courts, but in 1891 there was a constitutional amendment that created the Court of Civil Appeals, which became the Court of Appeals, the intermediate appellate courts for civil cases, and then the Court of Criminal Appeals. Oddly, in 1891, the Constitution said, we're going to add these courts of civil appeals, but you can only have 3 justices on those courts. Okay, that worked out fine, I guess, in 1891. But as the state grew, the caseload on those courts of civil appeals got big. And so they needed more intermediate appellate justices. So what do? The Constitution says you can't add 4 justices to the court, so we're just going to create more courts. In 1891, the first 3 courts were Galveston, Fort Worth, and Austin. Major areas. At that point in time, Galveston was the New York City west of the Hudson River. So the Galveston court was very, very, very important. 2 years later, they added 3 more. Or 2 more. They added Dallas and San Antonio. Fine. Part of the problem was it was a big state. And so if you lived in Amarillo and you had an appeal, we didn't have email, we didn't have electronic filing and all that stuff, so you had to mail stuff or ride horseback or whatever. And so they decided to create some more courts around the state. In 1907, we started creating what I call the 4 corner courts. Today, they're Amarillo, Texarkana, Corpus Christi, and El Paso. Spreading the work around, making it a little bit easier for people to do these things. As the population grew, we started adding more courts, Beaumont, Waco, and you can see how the map is changing over time. We're not going to go through a lot of these details, but then start adding Eastland, Houston first. They moved Galveston to Houston because after the 1900 storm, Galveston sort of lost its panache. And Houston was getting really big and important. And then in 63, they had Tyler and Corpus Christi. And so we're starting to get all these courts popping up around the state, but we're not done yet. In 1967, they added, and this is really fascinating, the 14th Court of Appeals in Houston. We only have one in Houston. Yeah, but we can only have 3 judges per court. And so instead of amending the Constitution, they just created another court. So what we have in Houston is really fascinating. They have the 1st and 14th have the exact same counties, in their district, 10 counties, they have one courthouse, one district clerk. And so if you practice law in Houston, or you're a judge or you're a citizen and you're trying to figure out what the law is, well, you don't really know if it's a dispute between the 1st and 14th court until your case gets decided and it gets assigned to one of those courts. So how do you advise your client? How do you plan your business? How do you plan your family? If you're a judge, how do you decide the case? And it turns out, so in new judge school, one of the programs that we had was conflicts between courts, right? So when you have 14 intermediate courts, if there's a novel issue of law, you may get 14 different viewpoints of what the law means. It turns out we learned in that program that the 1st and 14th lead the state in interdistrict conflicts. It's just a mess. But that's not that's the worst of it. But right here in the 5th court, we share Hunt County with the Texarkana court. Right? So it's the same problem. Whose law is going to apply? At least in that situation, the losing party gets to decide which court they want to go to. There are 4 other courts that Texarkana shares, and why does Texarkana get to share all these counties? Because it's a really small court, and they have a really small population, but they don't have enough cases. So they say, well, yeah, we'll just kind of cheat a little bit and share these courts over there. They're called flotarial counties. And we're going to talk in a second about problems that creates. We're not going to go through these in detail, but the legislature has historically been very active in redistricting the appellate courts to balance out workloads. And so there's a long history of doing that. And there's a history of creating divisions within courts. In 1975, they said, okay, we're going to have the Corpus Christi division of the Corpus Christi Court, and we're going to have the Edinburgh division. Depending upon where you are, and we're going to do that. Finally, in 1978, they knew what was coming, so we amended the Constitution to allow for more judges per court, so we can quit creating all these silly new courts. I didn't mean that, folks in Amarillo. And then we have in 1980 constitutional amendment giving the appellate courts criminal jurisdiction for the first time to take some of the load off the Court of Criminal Appeals. Well, okay, so as the state grew along the interstate highways, the population centers grew, and the dockets grew in those areas, and they got really, really busy, and not nearly as busy in the four-corner courts, as I call them, because the population centers didn't grow there. And then with criminal jurisdiction, it became important to add more justices because the caseload got huge. All right. So during the aughts, we had more redistricting and shuffling around to balance things out. We even changed the head count in some courts. And they kept going on in the aughts. But there haven't been any changes in the makeup of the appellate court since 2005. But a lot has happened. The state's grown a lot since 2005. Okay, so are there problems with our current system? We talked about the 1st and 14th in Houston and these inter-district conflicts. What happens is there can be delays. 4 times a year, the Supreme Court will look at the dockets of the intermediate appellate courts and say, we've got too many cases over here in Dallas, not enough cases over in El Paso, so we're going to take the first 50 cases that get filed in Dallas and ship them off to El Paso. Okay. The lawyers and parties from Dallas are saying, wait a minute. My case was here. Why am I having to go to El Paso to deal with it? I don't know those people. I didn't vote for them. And I have confidence in them that they're going to get it right. And they're supposed to be applying the law of the Dallas Court of Appeals. Do they know that? Are they going to have to research it? Is it different? It creates uncertainty, delays. So one year, the legislature has a mandate that each Court of Appeals it has to dispose of as many cases per year as get filed in that court. Don't have to be the same cases, but the numbers have to be the same. So what are they going to do to us if we can't get that work done? Well, they're going to cut our funding. That makes a lot of sense. But so one year, Right. We take cases under submission. Our year is September 1 to August 31. We start taking cases under submission September 1. And then by the end of May, we quit taking cases under submission because we've got to pump out a bunch of opinions to get our numbers up so that we don't get the legislature mad at us. And we spend, unlike the Supreme Court, the U.S. Supreme Court, we don't get to go travel to Europe and give lectures and do fun things like that. We're pumping out opinions all the way up until August 31st. So one year, at the end of May, the Supreme Court said, you know, here's 50 cases that we sent we took from your court to El Paso 2 years ago. They didn't do anything with them, and so we're going to send them back to your court. And oh, by the way, you have to dispose of them by the end of August. Well, what the heck? But just think if you're one of those parties whose case was ripped out of Dallas, sent to El Paso, nothing happens to it for 2 years, then it comes back to Dallas. Well, that's just no way to treat a customer. There's additional cost. There are voting issues, right? Think about the people of Hunt County. I mean, they're blessed and fortunate. They get to vote for 2 different courts of appeals, and you don't. They have a lot more voting power than you do. Is that right? Houston, and they get to vote for 2 separate courts of appeals. They have a whole lot more voting power than you do. Your case gets transferred to El Paso. You didn't vote for those judges. Is that right? Does that make sense? If we're going to vote for judges and have a system that does that, I think that's a problem. And then, Texas, God bless us, we're the only other state. No other state has overlapping appellate court districts, by the way. All right? We're the only other state that has district courts that bisect different appellate courts. And believe it or not, there are some district judges who sit in 3 different appellate districts, depending upon what day of the week it is and what city they're in. And they have to know the law of which court they're in that particular day. So, what does this problem look like on a population distribution? If the Equal Protection Clause, one person, one vote rule of proportionality were to apply to the judiciary, elected judiciary, you would have to have the population of an appellate district within 10% plus or minus of the average population per justice. As you can see, we start with Houston, the first 5, remember, are Houston, Fort Worth, Austin, San Antonio, Dallas. And then back over here we have Houston again. The major metropolitan areas tend to have more justices per population over the 10% rule, and the 4 corners of the more rural courts are less. If we applied that rule, constitutional principles, to elected members of this court, you would have only 2 courts in the state of Texas that would pass constitutional muster. And we can talk about the state of law on that issue. I will tell you, there is currently pending a lawsuit in federal court in Sherman now, challenging the constitutionality of the system. We'll see where that goes at the very preliminary stages of that case. So, how does one fix this problem? Somebody I know and have a lot of confidence in has proposed a 5-court redistricting plan that would go back to the first 5 courts and consolidate the rural courts under those umbrellas, if you will, and create divisions. Say, for example, the old 5th court becomes the new 5th court, and we have the Dallas division, the Texarkana division, and the Tyler division. Under this plan, the judges would run in primaries within their division. There's a residency requirement. You have to live in the Tyler division for a spot allocated to the Tyler division. But in the general election, you run district-wide. And you say, why would that be fair? Well, it's fair because these judges are going to decide cases. They're going to sit on panels of 3 district-wide. So you bring the different experiences of rural, urban together to decide these cases, which I think is a good concept, and do that. We're going to keep the courthouses open. We're going to keep the staffs in place so that if your case happened in Tyler, the appeal is going to happen in Tyler. Makes sense. So that we retain local contact, local input, and retain historic courthouses. This is their legislature came up in 2021 with a proposal with 8 courts, 7 regional districts, and a Texas Intermediate Court of Appeals that was going to handle administrative cases and constitutional cases under the Texas Constitution. This is the map that they proposed, and it was going to combine the Dallas court with Austin, bypassing Waco on the way. This proposal didn't get very far. Nobody liked it. Republicans hated it. Democrats hated it. So that one died. Legislature, what might a different solution look like? Here's the 5-part plan that I mentioned a little bit earlier. It kind of retains the same continuity that we had before. So the different shades of colors that you can see in there are the existing districts. And then what it would look like over here, and do that. We'll see if the legislature is going to do anything about that this session. What is for sure being proposed this session is a concept that I think is really fascinating, and it would be so wonderful for Texas if we would do it, is they want to create a 15th Court of Appeals. I'm not sure we need 15 when 14 is too many. But the 15th Court of Appeals would be the statewide intermediate court that we talked about from the last session that would hear these administrative appeals that affect everybody in the state. But it's also the business court. And part of what they're proposing this time around is a system of business courts, kind of like what they have in Delaware, North Carolina, and in 3 other states. That you have courts that are populated with judges and justices that are trained, experienced to deal with sophisticated business cases, shareholder disputes, mergers, acquisitions, takeovers, things like that, and very high-dollar, complex commercial cases. Why do we need that? Because you need people that are capable of handling these cases well. And so in my new job, I'm handling cases and appeals really around the country. And what I'm seeing is, for the most part, the way we do things, except for 14 intermediate appellate courts, in our judiciary is so much better in Texas than most everywhere else. We really, really run things easier. They're more user-friendly. It's easier to get things done. We have a much better developed body of case law than anybody else, really, even in New York and in California. But what we don't have are these business courts. And so what you want to do is, since the U.S. Supreme Court decision a few years back, Bristol-Myers Squibb, mass tort cases against a corporation have to be filed where they're created, where they're domiciled. So that you have consistency and certainty where those cases are going to happen. But people who want to incorporate their businesses in a state with a predictable system of courts that can handle their shareholder disputes, their business-type disputes. So Delaware has a huge advantage over us. If we were to add these courts to our system, I think, I'm looking at, make us the premier jurisdiction in the state of Texas, in the country, for businesses to incorporate. So is that a good thing? Yes. Yes, we like employers, we like businesses. And I tried to tell my Democrat lawyer friends who oppose this system, are you guys nuts? Really?
Yes.
The more cases that get filed in Texas, the better off we all are. Yeah, but we got these tort reform problems. Okay, great. Actually, what I'm seeing around the country is our tort reform is not out of the mainstream. Everybody else is doing the same stuff, and a lot of them are doing it before we are. But if those cases are going somewhere else, you're not getting them anyway. So why in the world would you oppose a system that I think would be so good for the state of Texas? So, if Bill were in the legislature, and thank goodness for everybody here he's not, we would do a massive restructuring. We would do the intermediate appellate court, 5-court program that I talked about. We would do the business courts, and we would do that all at once. Will all that happen? Who knows? The legislature's in session, and your property is always at risk whenever the legislature is in session. Comments? Questions? Yes.
If a judge interprets an opinion on there, are they setting a precedent for any future opinions, and how is that going to work?
Yes. Right. So the concept of stare decisis is once a court decides an issue, every time that issue comes up in that court in the future, they have to apply the same rule until either the Supreme Court says no, or the legislature comes in and changes the law. And it's called the rule of orderliness. The first time that a decision is decided, that's the one that applies. So that sometimes down the road, and this has happened to me, that issue will come up and the court will come up and reach a different result. Somebody will say, wait a minute, I want the whole court to consider that because 6 years before you said the exact opposite. And so the whole court, on our court in Dallas, there's 13. There's a Chief Justice and 12 other justices. We all have to get together and say, oh, crap, what do we do now? Well, okay, the rule of orderly says go back to the very first one and apply that. Okay? Because that's the predictability, consistency thing that I talked about a second ago. Yeah, yes?
What's your opinion on loser pay and plea bargains?
Well, plea bargains, I think, are essential to run the system. My observation is in the vast majority of criminal cases, there's not a whole lot of question about who did it and what they did. That's not to say it's true in every case. And certainly I don't want to demean the process of protecting an individual's rights because, right, it's life and liberty. Very, very, very important. But most of the time, you can get to a just result through a plea bargain because we know what the result's going to be, and we can save time, effort, and money. My observation, and again, this may or may not bear it out, but my anecdotal observation from sitting on the court is the vast majority of cases, on the criminal side, there's not a whole lot of debate about what happened and who did it. Particularly today, our sheriffs will tell you the forensic evidence is really good. There's typically an eyewitness. In Dallas County, probably much more so than in Rockwall County and Collin County, it's hard to go to prison. I mean, it really is. You have to be a bad person. You have to have done something really bad, or you have to have violated your conditions of parole or deferred adjudication. Right? If they give you a second chance and you screw that up, then they're probably going to put you away. But other than that, it's really hard to go to prison. And so plea bargains sort of fit into that system.
How about the loser pay?
Loser pays. All right, this may make me unpopular. Yes, in a lot of senses, we're moving towards loser pay in a lot of cases. Particularly under statutes we can call fee-shifting statutes that do that, and I think that's a good idea, right? Not to be confused with the question that you didn't ask, which is contingent fee cases. Are those a good idea or a bad idea? All right, so if you're on the defendant's side, you hate them. You think it's a horrible side. Oftentimes, the people who allegedly are hurt couldn't afford to have their cases heard if we didn't have contingent fee cases. Does that create some perverse incentives in the system for bad things to happen? Maybe. My friends that are really good plaintiffs' lawyers say, well, we don't want bad cases. We're not going to take frivolous cases because that's a waste of our time, effort, and money. You've got to find a balance in it, and you've got to have faith in the system that most of the time it works, and I think most of the time it works. Are there anomalies where it doesn't work? Yeah, sure. I'm starting to get the hook. So, yeah.
Hey, Bill. Jeff Morgan. I was listening to your interview with Eugene Ralph on the way over from 2 years ago. That was great. But a lot of the stuff that you're saying is predicated on, do we trust the courts? And I'm one of the people, I've talked with you about family courts and other things. I've been to over 150 cases in the last couple of years, either virtually or in person. I do not trust the courts. But I'm saying that, so with, say for example, the Supreme Court with Jeff Younger's situation, 8-1 let his ex-wife take his 10-year-old son to California to do gender transition. There's no more appeal. But I think that a lot of what you're saying is good theoretically. I look at the courts right now and I say, and I think you're a great judge, okay? But from
what I did here today.
well, no. Actually, I'd love to have you have a longer seminar someplace too. But I'm just saying that as far as, how do you mentioned Texas may be in a federal lawsuit against the constitutionality of their courts.
Well, that's why we have courts, so that these issues can get decided.
Well, we have so many courts that have conflicting opinions. There is not predictability, and when you look at family courts in particular, you're the one that told me that family courts are the wild, wild west of the law. So
I'm not sure I used exactly those words.
I think that was the quote.
Right, and we can talk more about that afterwards.
Absolutely.
What happens in family court, so much of it is a discretionary decision by the judge.
They can't be appealed either, because you don't really you don't take those appeals because it's the discretion of the judge.
Okay, I'm getting the hook, but I'll be around to answer questions.